Call case number 113751, State of Kansas v. Wyatt G. Brown.
Mr. Chief Justice, and may it please the Court. Kai Mann of the Appellate Defender Office representing the appellant Wyatt Brown. May I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you, Your Honor. In 2013, Mr. Brown pled no contest to one count of aggravated criminal sodomy, an off-grid crime. Pursuant to the plea agreement, Mr. Brown was allowed to request a departure onto the grid while the state agreed to stand silent. Mr. Brown was also allowed to request a durational departure from the grid sentence, and while the state would oppose such request, the state also agreed to not appeal if the sentence was at least 360 months in length. At sentencing, the district court found Mr. Brown's criminal history score to be that of a B. The district court then announced it was granting Mr. Brown's motion for departure, finding substantial and compelling reasons that the request was part of the plea agreement and that the victim was not made to testify. It then sentenced Mr. Brown to 360 months incarceration, and on appeal, the Court of Appeals vacated Mr. Brown's sentence because the district court failed to show the analytical path it took on both departures. Essentially, the district court said one set of departure factors, whereas our statutes require one set for departure off the grid to the grid, and another set of factors below if lowering the grid sentence. At the resentencing hearing, the district court again granted Mr. Brown a departure from an indeterminate sentence to the grid, relying on the same factors as it relied on at the first sentencing hearing. It then granted Mr. Brown's departure for a further durational departure relying upon the same factors. However, this time the district court sentenced Mr. Brown to 372 months instead of 360, resulting in an increase of 12 months. Mr. Brown again appealed, claiming his 14th Amendment rights had been violated via vindictive sentencing. The Court of Appeals affirmed the district court, found the presumption of vindictiveness did not attach, and that the record revealed no vindictiveness. However, Judge Boozer dissented from this finding that that the increased sentence was a product of vindictiveness, as the district court did not justify the increase in Mr. Brown's sentence, and the record revealed actual vindictiveness.
Did Mr. Brown, as a part of the plea negotiations, indicate that he received the 360 months or make the same commitment about not appealing?
There's no information on the record about Mr. Brown waiving any of his
because there
rights.
seems to be some statement about that he also, as a part of the deal, would not appeal. But there's no evidence of that. That was not a part of the agreement.
No, Your Honor.
I couldn't find it anywhere, but that's...
Yeah, correct. The only party to waive any appellate rights in this case was the state, waiving their right to appeal anything above or 360 months and above.
Thank you.
Thank you. Now, turning to some principles of law. The U.S. Supreme Court and this court in Rink has held that the due process clause of the 14th Amendment requires that vindictiveness against a defendant for having successfully attacked his or her first conviction or sentence must play no part in the sentence that the defendant receives upon a new trial or on resentencing. When there is a higher sentence the second time around, there becomes a rebuttable presumption of vindictiveness that the district court or the prosecutor may rebut. However, this is not to say the district court can never raise the sentence upon resentencing.
That's just if the record's silent, right? If the judge on remand or resentencing states some factors that have arisen since the original sentence.
Yes.
And the presumption doesn't arise.
Correct.
It only arises when the record's silent. Right?
When the record's silent, and I would also add a little caveat, because I think this is where the case here, or if the only reason was you were successful on your appeal.
On your appeal.
Yeah.
Right. Okay.
However, but getting back to the point, a district court can raise the sentence if they put the record or reasons on the record, and the Supreme Court has said those reasons should relate to the defendant's life, health, habits, conduct, mental and moral propensities, and events arising after the original sentencing. Which brings us to the case here. First, the judge offered no reason for the increase in Mr. Brown's sentence. When defense trial counsel asked the district court why it had increased the sentence by 12 months, the district court referred back and said, no more than just it's an appropriate legal sentence, and the court considered all factors in the sentencing guidelines to departure. That, to me, represents in this case that we have a presumption of vindictiveness that has not been rebutted.
And to the extent the judge said anything else as he was actually announcing the sentence or pronouncing the sentence, he just mentioned that he understood what the victim was talking about, the victim's mother.
Yes, when the victim's mother asked for increased time because Mr. Brown's appeal allegedly traumatized the family
And
further.
in fact, the prosecutor actually said that the fact that there was an appeal taken ended up in traumatizing the victim and the victim's family in exactly the way that was supposed to be avoided, right?
That's the contention. I would argue that
It's in the brief, isn't it?
it is in the brief. But I would argue that the true trauma that was avoided via the plea agreement was that the victim never had to testify. And in fact,
At a trial.
at trial or at a preliminary hearing, I mean, in fact, while we have statements from the victim's family, there's not a mention or a word from the actual victim itself in this case.
Mm-hmm.
And while we are sympathetic to the way this to the situation,
There was in fact no requirement that anybody from the victim, either the victim or the victim's family, appear at the resentencing.
Exactly. But in choosing to voluntarily engage with the process to lay this at the feet of Mr. Brown for exercising his statutory right of appeal is just plainly vindictive.
Exactly what the law disallows.
Yes.
I have a question for you. My understanding is that your fallback to the presumption, application of the presumption, is that the actual vindictiveness is demonstrated on this record. But that's kind of a misnomer, isn't it? I mean, we don't have to believe that, because vindictiveness sounds like something about the personal animosity of the judge. Right? It sounds that way, doesn't it? That would be the ordinary meaning of vindictiveness, right?
Yeah, and that would be the ordinary sense in which this arises, dealing with the
But is that what actual vindictiveness really means as a matter of law? Or does it just mean you did it for the wrong reason?
No, I believe I just want to make sure I'm answering the right
Sure.
question. So if the judge were to say, I don't like the shirt you're wearing at resentencing, I'm going to give you an increased sentence, whether that would be a type of vindictive, I guess
I just think that it sounds so pejorative about the motives of the judge when you say actual vindictiveness, as opposed to just really meaning that it was done because of success on appeal.
Yeah, and I think
That's the wrong reason.
Yeah, and I would agree with that.
Okay.
Yes, I know the term actual vindictiveness feels very strong.
It's kind of like the old days of prosecutorial misconduct,
Yes,
as opposed to prosecutorial error.
Right. Mainly relying on improper legal factors or factors related only to the success of the appeal. Yeah, I did not get the feeling that the judge in this case was angry or upset or throwing gavels.
The
So that-
record doesn't read that way.
I'll teach you to appeal my sentences. You would say that's vindictive.
Yes, I would say that is plainly vindictive. And
I would assume you would take the same position if it wasn't, I'll teach you, but rather we have all this evidence of added trauma to the victim and the victim's family. I understand you say that's not present here, but hypothetically, if it were present, your argument would still be that's an improper reason.
yes,
Even if this appeal did cause these additional things, which aren't, it doesn't have as much of a pejorative overtone. It's more like the judge trying to look out for the victim and the victim's families, but the point is that's still improper.
Yes, and the reason why it's still improper is because it's not the only thing the trauma flows from is a successful appeal. And Frank,
It can't be an artifact of the appeal.
exactly, it has to be a separate reason, and for something occurring subsequent to the original sentencing, has to be something new that the judge wasn't able to latch on to at the original.
Does it
sentencing.
have to be something new though? Because the first sentence was reversed, and so that would indicate that the judge did something wrong the first time around.
Yes.
And so why can't the judge, trying to do it correctly, reassess based on facts that aren't new?
Well, I think that's where we get to
The language from, is it Seymour? What's the old opinion?
yeah, from Pierce, I believe.
No, I'm not talking about that one. I'm talking about our opinion.
Oh,
having
Rink.
to do with all the Jessica Law cases.
Oh, Spencer.
Spencer.
Yes,
Thank you.
yes,
Seymour. I thought it was an S.
Yeah.
I got to the consonant, but not the whole word. I think there's a differentiation from Spencer here. So I want to see if you agree with me. In Spencer, we were saying that the judge's expressed reasons for departure were not substantial and compelling.
Correct.
They were substantively infirm.
Yes.
Here, like in Rink, we have a procedural infirmity,
Yes.
right?
Yes.
A failure to state reasons,
Right.
which is a procedural error, not a substantive error.
Right. And in fact, I think it's striking in this case that through 3 instances of stating substantial compelling factors, we have the same 2 factors appearing all 3 times. I mean, it's clear what the district court was trying to do at the original sentencing. It just failed when it's failed to cite the factors a second time.
Well, but at least in theory, you could see a district court getting that ruling back, reversing the sentence and saying, okay, now I have to actually jump through these procedural hoops, if you want to call them that. I have to articulate the reasons. And now that it comes down to it, I find I can't do that. Doesn't that change the potential of the sentence?
I mean, I think if the district court is still relying on the same corpus of information that it relied on the first sentence, I still think that would be a vindictive sentencing. The way I've looked at this and tried to put this together in my head is kind of like an equation. If we have x plus y equals z, x plus y is always going to equal z. If you want to get a different result than z, it's got to be x plus y plus q. You've got to have a new variable, or else if all the variables are the same, the equation stays constant.
That logic makes a lot of sense, but it assumes that the y was present the first time around.
That's true.
And my point is, I guess, that the first Court of Appeals decision reversing the sentence said the y wasn't there.
But I also think it also matters to what the y was. If the y is, there's, your criminal history score was wrong and in favor of the defendant, well, then the y requires the sentence to be higher to comport with the statute. But whereas if the y is just, I forgot to say the same 2 factors again and I have no other information, I guess basically on the long and short,
But that presumes that the district court used the same factors the first time. And I think that's why the Court of Appeals reversed and says you have to state them, because we're not going to presume that when you went from the grid downward, you used the same factors you stated from Jessica's law to the grid.
right.
And you're saying that's the y that was there. Well, we don't know that if it wasn't stated, and that's why they got the first reversal.
Right, but in this case, we know that y is there because at the resentencing,
Right.
the y was inserted, and again, that doesn't change the equation for this purpose.
But the question was, if it went back and the district court says, well, I didn't state the y, so now I'm going to take a look at the factors that are in a different statute than Jessica's law, and the court could state those factors and end up with a higher sentence without being vindictive.
I disagree. I think it's particularly in this case where the court is relying on the same factors over and over.
Well, but that's the point, is how do we know they're relying on the same factors? It seems to me your argument is, look, had the judge done this correctly the first time around, the sentence would have been 360 months. And I don't see how you connect that final dot. How do we know that? How do we know that had the district court judge done everything procedurally appropriately the first time, the sentence would have been 360 months?
I mean, because no other reason was given for why he got 372 months on the second time, except for the district court stating it was dealing with a quandary with understanding what the victim and the family is telling us, and in part because there is nothing new. There was no...
So that gets to affirmative evidence of vindictiveness.
Yes.
Okay.
What is the remedy you're seeking before you sit down here?
If we find that it is characterized as a vindictive sentence, what do we do?
Remand for resentencing in accordance with due process and using the original 360-month mark as the marker for judging vindictiveness.
So it still is a resentencing that would allow for something other than a 360-month sentence.
I mean, Yes, I would encourage this court to remand with instructions for 360 months, but I'm not sure with Spencer if that is an option. However, I think once we have a finding of vindictiveness, then I'm not sure if different considerations come into play to where we should just send it back with specific instructions for 360 months to not allow this to happen again, or if we go the route of Spencer and allow the district court to reweigh the factors. Obviously, I would be in favor of this court ordering a 360-month sentence, but I think at a bare minimum, the remedy should be resentencing with 360 months as the reference point for judging vindictiveness.
Do you think Spencer or something else prevents us from vacating and reinstating the 360?
Absolutely not. No, I do not. I think that would be also remedy. The problem with this is that there's so little case law on this. It happens so rarely. I looked to Rink, but Rink had different issues. They just vacated, but they also had the Habitual Criminal Career Act, and so that was jumbled. But I think that it would be a completely appropriate remedy for this court to reinstate the 360-month sentence.
Except that it was made without findings. I mean, that's the difficulty.
Yes. I understand that at the end of the day, there is no affirmative reason for it to be more than 360 months because there was no reason, no new variables presented at the resentencing to raise that sentence. And I see I'm out of time.
Any more questions?
I just want to make sure I understand. Like your ideal would be we just vacate and reinstate. Colleagues just pointed out one reason why we might not want to do that. Your backup would be that we send it back with some kind of ceiling unless there is something new that's stated and it isn't an artifact of a successful appeal.
Correct.
Is that right? Okay, thank you.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, the appellant or appellee, State of Kansas, appears by Kevin Hill, Brown County Attorney. As noted, the sole issue before this court is whether the district court's resentencing of the defendant to 372 months in prison violated the defendant's due process rights. The defendant was convicted of one count of aggravated criminal sodomy against a 12-year-old child. The crime was an off-grid person felony for which the standard sentence was life imprisonment. Despite the fact that this was the defendant's second conviction for a sex crime against a child, the district court granted the defendant's request for departure to the Kansas sentencing guidelines. Now, based upon his criminal history score of B, the state asked for the aggravated sentence for severity level 1 person felony for someone with a criminal history score of B of 618 months. And despite that recommendation and hearing from the victim's mother about the devastating impact that the offense had had on the victim and family, the court at the initial sentencing granted durational departure of 360 months. Now, the basis for the durational departure, the court referenced that the defendant did not require the victim and her family to relive the crime by contesting it and requiring the victim to testify. Now, as this court's aware, and as has been mentioned, the court failed to cite a separate basis for both departure to the guidelines and the durational departure, but used the same basis in simultaneously granting both requests for departure. As such, the Court of Appeals, and I think this is important, found the original sentence to be an illegal sentence and then remanded the case back to the district court. They did make particular note that the district court may reevaluate the factors bearing on sentencing, including adding to them re-grant or deny departure from Jessica's Law and a dispositional departure from the default guidelines to probation, as well as a durational departure.
And that language came out of Spencer.
That's
right?
correct. So at the resentencing, and I would disagree that the district court was silent. If you look at the concluding part of the resentencing, yes, when asked, I wish the court had been a little more detailed in giving the reasons, but if you review the transcript, there was reference throughout. And on page 18, the state said, the simple fact is that this has resulted in extra trauma to the victim and her family.
What's this?
I'm sorry, the transcript would be record on
Excuse
appeal.
me, counsel. Not What is this in that sentence? What is this?
The resentencing
Which was a result, an artifact of a successful
of an
appeal.
appeal. That's correct.
Thank you.
How does the district court, from an evidentiary standpoint, know that the family had further damage?
There was a testimony or a statement from the mother that was read into the record, and the mother
Is that
did address
evidence?
the court. I'm sorry?
Is that evidence?
It was
she
considered-
under oath? Was she subject
She was not
to
under oath,
cross-examination?
no.
She wasn't
no.
subject to cross.
She was just given the opportunity as a victim to address the court at the resentencing.
Okay, I mean, and thought we decided in the Atkinson case that the court had to base its sentencing decisions on evidence.
I think the court can base its decision also on statements made to the court. And in this case, just under the victim's rights and the victims being able to address the court, I think the district courts properly can consider what the impact of this has had, and that's why we had the victim impact questionnaire. And that was also in the original sentencing. The victim impact questionnaire talked about the trauma that this has had.
But that doesn't matter for the purposes of what the judge said, because he's talking about aggravated damage caused by the resentencing. So we're past whatever was in the original record.
Yes.
So we're talking about something new has happened because this guy appealed and won.
That's correct.
Something new has happened that has hurt the victim's family, and it looks to me like we just added a year onto the deal.
Well, and I think it's important to look at the fact that the original sentence was a tremendous break. It was a durational departure, and it was based upon the defendant not taking action and exercising certain rights. I mean, he didn't exercise his right to a trial, and I don't think anyone would argue that if the court had imposed a guideline sentence in the 600s, that he was being punished for exercising his rights to a jury trial if he had chosen that route and required the victim to testify. So I think in this case, the district court was giving a break to the court in recognition of the fact that he had given up certain rights. And so I do think there's a distinction between punishing someone for exercising rights and rewarding someone for not exercising those rights.
Well, the family said add time to this guy's sentence because he appealed and won.
I would disagree that that's what they stated. I think what they were stating is that because of the defendant's exercise and his choices, they are now coming back to this court for a matter that they thought was behind them, and it just reopened all of those old wounds.
The sentence says, we would like to see further time added. And the sentence before that is because of the further damage done, and the clear reference to all that is to the fact that the appeal was successful. And then the judge, I'm just telling you what's causing me trouble here, and I want you to push back on me. Then the judge, when Judge Weingart, when he gets around to doing the sentence, he says, I really understand what the victim's mom is telling me. And I really, really do. And she said, add time to the sentence because we're here.
And you
It's
chimed
pretty hard not to connect the dots on that one.
And then you chimed in and said the same thing. That I don't know, he's the one that decided to appeal, and that's part of the basis of you also requesting more time than was originally given.
Yeah, when I was responding to him making that decision, I think that was in response to the court's statements regarding choices that had been made by appellate counsel, and then his trial counsel was intimating to the court that his client had nothing to do with that, he had no control over that, and he had no contact with appellate counsel for that line of, or for the tactic that was taken. So, and that's, in our opinion, I mean, we're not, I'm sorry.
I guess my question to Mr. Mann is the same thing to you. There seems to be an implication that this case was over at the time of the first sentencing, and that there was an implication with the plea agreement that there would be no appeal. Was that the understanding? Because I don't see it anywhere. You made a statement you wouldn't appeal unless it was under a certain amount, but the defendant made no
I would agree, yeah. The state made the agreement not to appeal a sentence of at least 360 months. The defendant did not make any such agreement.
Well, your statement was that it was strategically silly when he caught that break to jeopardize getting a 600 and some month sentence. Wasn't that he was precluded, but you just thought it was, as a matter of strategy, you couldn't understand.
Well, I think
Isn't that what you were saying?
Yeah, I think district judge mentioned that, and we were also, a little incredulous that they would expose him to that, but I don't think that's a sign of vindictiveness. That was just a comment made at sentencing. I think in this case, it's the state's contention. We're not punishing the defendant for exercising the right to appeal. We're just of the opinion that he shouldn't be rewarded for exercising that right when not exercising certain rights was the basis for the durational departure to begin with.
Counsel, I'd like to look at some language in the transcript. It says prosecution. That would have been you.
That'd be correct.
It says, I think was mentioned earlier, I do think some additional time is warranted. And then the next paragraph says, I think the major finding that this court made was cooperation and not putting the victim through trauma. In other words, the original plea bargain. But then the next sentence says, he has now done that, which I read to mean you're now telling the judge he has now put the victim and her family through this trauma. And you tie that in with, so he should get additional time. Am I misreading something there?
I was referring to the fact that his decisions had caused additional trauma because they thought this was closed, and that because of that, he should not be entitled to the same break that he received from the court when he did not put them through the trauma of certain things by exercising rights. So it's a fine. There is a distinction in that we're not punishing him for exercising rights just as if he had exercised his rights to a jury trial. I'm sure our request would have been for more time, and the judge's sentence would have been longer because the victim then was traumatized and required to testify. So he had the right to exercise his appeal, but it's the state's contention that he can't cry foul now that he's not entitled to the same substantial durational departure and break from the court from a presumed reasonable sentence under the guidelines when he decided to exercise those rights. And because of that exercise of those rights, it did cause trauma, which was written or read into the record by the mother, that they're having now to come back.
It sounds like you're really arguing is by virtue of the appeal, the defendant should lose the benefit of the bargain that he struck in the plea deal.
Benefit of the reward from the court,
yeah.
Sure.
And if that, I guess it seems that the problem with that argument is the problem Justice Rosen identified, which is he never waived his right to appeal in the plea bargain.
I understand, but in this case, it's not punitive in the fact that he did receive a substantial departure from what the legislature and this court has found to be a reasonable sentence for someone with his criminal history and with the level of the offense. So as far as benefit of the bargain, I more say he's just not entitled to, you don't have a constitutional right to a break, and in this case, he's not entitled to the same break he received from the court when he waived his rights, came in, took accountability, and didn't put the family through the trauma.
Well, let me read you a sentence from Judge Boozer's dissent. A plain reading of the transcript manifestly shows the only reason Brown's punishment was increased was because he exercised his statutory right to appeal. Do you agree or disagree with that?
I disagree with that. I think it takes it out of context. You can say that's the end result, but he wasn't being punished. It's just he was not the recipient of the same break he got the first time around because those factors aren't the same.
But if any of his sentence is attributable to a rationale that is not lawful, don't we have to reverse that sentence?
And I would disagree that it wouldn't be lawful. I think it is lawful because the court has...
You think it's okay for a court to consider the fact of the appeal in deciding how many months to sentence the defendant to?
Not in that context, but I think the court can consider the fact that a defendant received a break by giving up certain rights the first time around and then didn't give up those rights and then exposed victims and families to
But he didn't give up the right to appeal.
I'm sorry?
He didn't give up a right.
I understand, but he also didn't.
And what's the difference between punishment and withdrawing a benefit? Doesn't withdrawing a benefit feel pretty much like punishment?
In our opinion, no, because in this case, he received a sentence because he did not contest things and he owned up for what he did. Yes, he has a right to appeal, but the result of exercising that right to appeal is that we no longer were in the same situation we were at the first sentence, and that is we now have the victims coming back because of something that was contested by
What
him.
you're really saying is that defendant argued to the sentencing court, give me a break because I'm protecting the victim from additional trauma, and then turned around and caused additional trauma.
Yes.
Is what you're arguing.
Yes. And then that would not be vindictive. And I would agree with
It's
him.
more of an estoppel if you're going to argue that you should get a benefit because this is how you're acting, and then you turn around and act differently. But I don't know how that kind of equitable estoppel works as a matter of law.
When you have a statutory right to appeal.
Right.
The other thing is, I think all of us who've done this work for a while have seen lots of cases where it's pretty obvious. I mean, just the way plea bargaining works, right? Usually people, they bargain, right, on what they're going to be charged with under our sentencing guidelines to...
Yes, I agree
I mean,
with
you
this.
do that every day as a prosecutor, I'm sure.
Yes.
That's the way it works, right? So people end up with shorter sentences because they're cooperative, right?
Yes, certainly.
And they waive the right to jury trial.
Especially in sex offense cases.
Sure.
Certainly.
Happens all the time. The system would break down if we didn't have plea bargaining, right?
Yes.
So there's no law that says that a person can't get a benefit or can't be punished for going to... I mean, there's no law about that. But we do have very clear precedent on punishing somebody for taking an appeal and being successful. That's the problem, is I think you're trying to kind of bleed over from what happens in the trial setting, where somebody waives the right to jury trial, and kind of requiring them to also waive the right to appeal, and they're just different.
No, and I'm not asking that he waive right to appeal. I'm just saying he shouldn't be in a position where he can complain about not receiving a bargain that he got at the initial sentencing when his actions led to circumstances that were not existent in that first sentencing, and that is he caused more trauma because of his... He certainly has the right to appeal, but I don't think he has the right to receive the same bargain, the same breaks from the court.
Except the U.S. Supreme Court has said he does.
I would disagree, because I think that presumption of vindictiveness would not apply because the initial sentence was an illegal sentence. So I think the majority in the Court of Appeals was correct in that the presumption of vindictiveness would not apply here.
And would you say that Mr. Brown was successful on appeal?
I'm sorry?
Would you say Mr. Brown was successful on appeal? He got 360 months, and they said, no, that's illegal. Send it back, and you can consider whatever you want, and open it all back up again. We keep talking about being successful. It's almost like he snatched defeat from the jaws of victory.
And I would agree. It depends on how you define success. He was successful in getting a remand, but I know I'm out of time. Just in conclusion, when you were asking if it's reversed, I certainly think because of your precedent on the court being able to look at new factors, which will exist in this case, that there shouldn't be a floor or ceiling other than the sentencing guidelines themselves.
Do we have any further questions? What are you asking the court to do?
We're asking the court, to uphold the decision and affirm the decision of the Court of Appeals, which also affirmed the resentencing of Mr. Brown.
Thank you, counsel.
Okay, thank you.
May it please the court? At this time, I have no additional prepared remarks. However, yes.
Yeah, well, I assume you're inviting questions.
Yeah, that's exactly where I was going.
And my question is, how was Mr. Brown successful? Why was this a successful appeal, he was actually asking for less time, right?
Yes, he identified reversible error in the sentencing proceedings, and it's important to remember he did get a break. However, he did not get the full break he could have gotten. He requested 293 months. So upon resentencing, there's at least a chance that he could have gotten a better sentence.
And there was a chance he could have gotten an increased sentence.
There was a chance he could have gotten an increased sentence. However,
It wasn't the, excuse me, but wasn't the Court of Appeals directions, remand directions, that the district resentencing court could consider all these other factors?
I don't read the remand directions in the first Court of Appeals opinion as directing the court to do anything but follow the law, which Spencer had only been decided 2 years prior at that time. I think the Court of Appeals was just saying, hey, when a Jessica's Law conviction or sentence is vacated, this is what our Supreme Court has said the proper remedy is.
Any further presentation?
No.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.